Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope you're doing well on this day, Monday, March the 30th. Wow, a lot is going on. I made my bow. Look at my bow. Yep, I knitted this bow. I made some mistakes, but it's okay. And it is huge. So it doesn't really belong on the top of my head, but it belongs like in the back. But it's okay because it's here. And so this is my first attempt at knitting a bow. And here it is. It is huge. It is huge on the top of my head. It needs to go the other way around to be on the back of the hair, but it's okay. And I just got these loveys in. Look at these. Look at these loveys. It's like a bundle of joy. Can you see this? This is like a peachy pink. And then we've got a nice little green. And then we've got like a light blue. And then this is hot pink. Oh, so I don't know if you can see this, but this is, do you see this? It says Gilpin. Gilpin, that's right. If you know, you know. If you don't, I'll tell you. So if you like the British baking show and you're a knitter, there is a TV show in Britain called Game of Wool, and it stars Tom Daley, who is obviously an Olympic medalist. I think he won bronze. I don't think he ever won gold. An Olympic diver, and in Britain, and he won a couple of medals. And he knits and crochets, and so they made him be the host of this show called Game of Wool. And the judges were Gilpin, and I'm going. Oh my gosh, the other person's name just okay. Very, very famous in the knitting world of Britain. These two women who live in the Scottish Highlands, and they have a yarn barn, and they've been knitting for years, and they have been doing some knitting for runways. So they do a lot of couture knitting, and it is just amazing. And so now they are knitting for a knitwear designer, or maybe they're the knitwear designers and the other people are selling them. And so they just, they've been in the industry for a very long time. And Gilpin is doing a test knit for her Coda jacket that she had, that she made a long time ago, apparently. And she's like, I need some people to do this. And I'm like, okay. So it's a long awaited process. This is the picture of the, oh, well, okay, maybe, where do I need to go? No. Oh, you can't see it. Maybe if I go like this. No, nope. The white paper, it does not like the white paper. Anyways, you can kind of see it if I kind of go like this. Yep, there we go. A little bit. Okay, there we go. That's what the jacket looks like. So we are doing some test knitting right now, and I ordered these loveys, and these loveys just came in the mail. But you're not here for the knitting, you're here for the law. I could do a whole knitting channel, but I don't think people would be interested in the knitting channel. Only the people that knit would be interested. And anyways, but you get to see my lovely projects, and this bow is just amazing. And oh, it's so lightweight. It's made out of this alpaca. Made it out of the alpaca silk. It is like heaven. So much heaven. I hate to even like reverse it, but we'll see. And remember, I got a whole bunch of colors and stuff. So I'll do some more bows, but I think I'm going to make it a little bit smaller. And it took a long time to do. If you saw, I was doing it forever and a day. So it's all good. It's all good. All right. So what do we got going on? Well, there's a lot going on. Even if there's a trial going on, it sometimes is nice to take a break from a trial and just sort of get back and recap on cases and stuff that we covered. So what am I covering today? I am covering the appeals for Richard Allen. If you don't know who Richard Allen is, Richard Allen was convicted of unaliving two girls in Delphi, Indiana. And I'm just going to kind of share these pictures with you. So this is Richard Allen. He went through a trial. So there are two girls, Abby and Libby. They lived in Indiana. We'll go over the story. They lived in Indiana. They were going onto this bridge. It's called the Monon High Bridge in Indiana. They were going for a walk. Long story short, they were found unalived. One of the girls videotaped their assailant coming towards them, and this is the video of it. And people attributed it to be Rick or Richard Allen. He said that he was there. He put himself there at the days of the events, and they had put out sketches and stuff of what he looked like. Long story short, he was arrested. He was convicted. It wasn't for a very long time. I'll go into the details with you exactly what I wrote up about it, and I did a long thing about it. So Richard Allen was found guilty on November 13th, 2024 of 2 counts of murder and 2 additional counts of murder while committing or attempting to commit kidnapping in a court in Delphi, Indiana. He was convicted of killing Abigail Williams and Liberty German at 1:35 p.m. on February 13th in 2017. Libby, who was 14, Abby was 13, went for a hike on the Monon High Bridge Trail by Deer Creek Township in Delphi, Indiana. They were dropped off by Libby's older sister, Kelsey, at the Mears Farm entrance. And why is that important? There are 2 entrances to this park. About 2:07, German posted a picture of Williams on the bridge. Libby was supposed to be picked up by her father around 3:15 p.m. When their calls failed to be returned, texts that the families were trying to locate the girls and they couldn't find them. So around 5:30 p.m., they decided to contact the authorities and ramp up their search efforts. At 2 a.m., the search was halted due to low visibility and would resume around 6 a.m. Just to remind you, it was an extremely warm day in February in Indiana, and the girls were out walking around. If you see them, they only have like light jackets on for that day. And then probably like a cold front came through, and so low visibility happened, and then they resumed about 6 a.m. On or about noon the next day, on February 14th, the bodies of the girls were discovered around 0.5 miles east of the Monon High Bridge, just north of a bank at Deer Creek. Upon the recovery, Libby's phone was discovered and underneath her, and revealed that she had recorded a 43-second video of her on the phone, and the video captured a man in a muffled voice say, "Guys," and then down the hill. Abby rushed past the camera. It's believed that one of the girls said, "There's no path down here. We've got to go down here," which means that they're at the end of the bridge, and they thought that the gentleman wanted them to go forward, which there really wasn't a path, and so they had gone down the opposite the side. On February 15th, 2017, a still image of the video was released to the public. So the case, attracted widespread attention because who would unalive 2 teenage girls at this park? So it took a long time. There was no leads. Nobody knew anything that was going on. So April 22nd, 2019, 2 years later, the state police announced a new direction in the case, and they released a new sketch urging the public to take a look at and listen to the audio. They also made an appeal. October 2022, Indiana State Police announced the arrest of Richard Allen. So it was alleged that Allen was there that day. He put himself there that day. When he had told the police that he was there, I think he gave some misinformation. And then one person who was in the office and was going through files found this file years later, and it was about Richard Allen and his address and some bits and parts of him, and that they went ahead and took a look at it again. But when Richard Allen was interviewed, he was interviewed by the DNR. He wasn't actually ever interviewed by the state police when he first initially said that he was there. So eventually he gets arrested. He did fit the build and the type of the person that they were looking for. He said that he was there, but of course, it's only witness accounts. And then I think his wife stated that he'd come home and he was all dirty because allegedly he had run back through the woods back to his car through a field and etc. Well, I mean, not allegedly, he was convicted, right? So they had to bring in a jury for it. So they went to Tippecanoe County in Indiana, which is up like by Purdue University. And because Delphi is over here, Purdue is up here. And they had to get jurors from this area to bring them over. So the initial trial was set for March 20th, 2023, but it was postponed to allow his defense team to review discovery materials. November 29th, 2022, Judge Francis Gull issued an order to unseal the probable cause affidavit, which led to his arrest. According to the PCA, the footage recovered from the German's phone showed one of the victims mentioning a gun. Investigators also believe that the suspect is the man seen in the video. Investigators found the .40 caliber unspent round less than 2 feet from the victims' bodies. In between the victims, it was later determined that the round came from a gun owned by Richard Allen, and he put himself there. A witness said that she saw a man walking away from the bridge wearing a blue-colored jacket and blue jeans and was muddy and bloody. As you can see on the video, that fits a man's description on the video. Another witness and a tip mentioned that a car was parked oddly and that matched his vehicle. Remember that he said that he was there at the tip line. He matched the description, the sketches. December 2nd, 2022, judge issued a gag order until January 2023. The suspect's defense attorneys argued in a motion and moved the trial out of Carroll County based on concern about juror bias due to the attorneys describing his extensive media coverage. So here's the timeline. January 13th, 2023, the request of a change of venue. January 15th, the judge grants the request and moves the trial out of Carroll County, which will be held in Allen County. 2023, Allen's defense team argues that the evidence is insufficient, questioning the reliability of the bullet evidence, suggesting that other individuals, like a religious cult, was involved. July 2023, a special judge rules that pretrial documents, including certain evidence details, remain sealed. And then October 14th, 2024, there was a jury selection in Fort Wayne County. 12 jurors and 2 alternates were selected. They were then transported to Carroll County and were sequestered for the 17-day trial. Opening statements began in the case where the prosecutors maintained that Allen is the bridge guy that Libby captured on his phone. So the defense was prohibited from submitting evidence of a third-party perpetrator. They had sought to bring in various theories of Odinism, geofencing data, and alternate suspects. They weren't allowed to do that. The other thing, too, is that the incarceration of Richard Allen. So apparently Indiana didn't know what to do with him, or maybe they did know what to do with him, and they put him in state prison instead of like the county jail. And they isolated him. They also had he had therapy sessions and stuff, and he basically allowed he was hallucinating, etc., because it was a very long time before he was tried. And the defense said, hey, listen, he's saying things that he doesn't mean to say because he's cuckoo bananas, and it's a product of his being incarcerated in this jail for so long that he's going crazy. Plus, he was also on different psychotropic drugs as well. So could you believe he made some jail confessions? Could you believe that? So could the prohibition of the third party culprit defense be a grounds for an appeal? Was the treatment of Richard Allen during his incarceration at the state prisons a reason for him to confess? Were they a hallucination of his medication? Or did his mental state deteriorate during his solitary confinement? Did he receive a fair public trial? Excuse me. And will these issues come up for appeal? Well, guess what? It's appeal time. So Richard Allen's lawyers made an appeal. So we're just going to read this article because it makes it just a little bit easier. All right, let's go ahead. Richard Allen's appeal focuses on what wasn't said in the Delphi murder trial. Attorneys leading to an appeal for Richard Allen, the Delphi man convicted of the 2017 murders of Abby Williams and Libby German, filed a 113-page brief Wednesday arguing, this was December of 2025, that the court made a series of errors during and leading up to his 2024 trial that tamped down evidence. An argument signaled in recent months, court-appointed attorneys Stacey Uliana and Mark Lehman contended the court refused to consider what defense calls false statements and reckless omissions by investigators when they asked the county judge for a warrant to search Allen's Delphi home in the weeks leading to his October arrest. So here's Abby and Libby. This was the courtroom. This is the video that I want to say Abby caught. And then this is Richard Allen when he was arrested. The brief filed with the Indiana Court of Appeals also argues that Judge Francis Gull erred by allowing the jury to hear a series of statements Allen made that he was the killer, ignoring that the admissions were made while gravely ill and broken by months of unprecedented pretrial solitary confinement. He was in confinement the entire time in an Indiana prison. And the prison, from what I believe and heard, the prison was terrible conditions. In fact, I think that the prison may not exist anymore. Anyways, the brief, coming in with a court-approved extra 10,000-word limit due to the complexity of the case, also argues that Allen's defense team was blocked from offering evidence tied to a theory that the girls were unalived by other parts of a ritualistic killing tied to a pagan Norse religion, Odinism. Because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. So the state has 30 days to respond. And the state responded, but I think they just recently responded. Anyways, Allen was convicted in November of 2024 after a trial that lasted nearly 5 weeks, including selection of a jury from Allen County due to the high profile coverage of a case that took 5.5 years to produce on arrest. Gull, an Allen County Superior Court judge appointed to the case shortly after Allen's arrest. Abby, 13, Libby, 14, each 8th graders at Delphi Community Middle School were unalived February 13, 2017, after being dropped off to spend time during a day off from school on the Monon High Bridge. Okay, the trial was built around a prosecution case that said Allen was, in fact, Bridge Guy, linking him through dozens of admissions months after his arrest, despite no DNA evidence at the scene. In a search of his house 5 years later, to an unspent bullet found at the crime scene that investigators say had to have been in a gun later found in a search of Allen's home. Allen's defense team was frustrated during the trial by a series of pretrial rulings by Gull that had said hamstrung the case. The brief details that Allen went to the police in the days after Abby and Libby were killed, telling an officer that he had been at the Monon High Bridge trail that day. After the interview, the lead was marked cleared and a report misfiled. His attorneys wrote in the brief, Allen then returned to his job, family, and home in small Delphi community. For the next 5 years, he did not sell his car, destroy his clothes, dispose of his gun, or relocate, but continued his normal routine. No witnesses identified Allen as Bridge Guy. When the report was rediscovered in September of 2022, law enforcement insisted Allen was Bridge Guy without a single eyewitness. Over the next several years, the state built its case against Allen. But one thing that is gone missing is his phone. So here's a funny or interesting thing is that he had all of his cell phones throughout the time period that cell phones existed, except for the one that was during this time period. So take that with a grain of salt. Allen's attorneys contend that Gull should have granted a Franks hearing ahead of the trial to deal with an attempt to prove investigators lied or hid crucial evidence from a judge when they received a search warrant for Allen's home in October of 2022. In these motions, Allen's trial attorneys had leaned to a theory that suggests the girls were ritually sacrificed by worshippers of Odin, not by Allen. Allen's attorney wanted to suppress evidence from the search of his Delphi home, including a gun that investigators contend matches the ballistics of an unspent bullet found near the girls' bodies in the woods. The brief filed this week argues that the then detective Tony Liggett, now the Carroll County Sheriff, got the warrant after misleading a county judge by omitting and altering witness descriptions to connect Allen to Bridge Guy, and by misrepresenting that Allen admitted he wore a blue Carhartt, just like Bridge Guy. The brief contends that Liggett misled the court in 4 ways, including that descriptions offered by witnesses on the trail in 2017, ones that led to sketches distributed to the public during the investigation, indicated Bridge Guy had brown, poofy hair, in his 20s or early 30s, youthful and medium build. At the time of the murders, Allen was 44 years old, 5'6", and had very short hair. The brief contends that Liggett found out a witness's description of a man walking on the county road near the trail that day wearing a tan coat. It argues that Liggett told the judge that Allen had admitted to owning a blue Carhartt, but left out the jacket. Allen had one of his wife. Allen had was one his wife said in 2022 that he bought a couple years ago. Had the court known Allen simply admitted owning a blue or black coat does not probably every 50-year-old man, it would have known there was no connection between him and the Bridge Guy. These misrepresentation and omissions misled the judge into believing multiple witnesses saw Allen and his car, when in fact they described someone else and a different car. Allen's attorney argued in the brief, once the affidavit is corrected, there is no probable cause. Without the fruits of the search, the gun, a casing, and a hope box with the Carhartt, the knives, and computer, the state cannot prove to the jury would not have convicted. Tellingly, the trial court was willing to schedule a Franks hearing when Allen was represented by Fort Wayne attorneys, but refused when the original attorneys were reinstated. That's right. The judge threw the attorneys off the case and then they were reinstated. It was a fiasco. The brief argues that Allen wasn't well physically or mentally when he told his wife and mother and inmates and guards assigned to watch over his cell at Westville Correctional Facility that he killed Abby and Libby. Remember, he had jailhouse confessions. Moved from the Carroll County Jail days after his arrest as part of a safekeeping order, Allen spent 13 months in state prison, largely in a solitary cell in a segregated portion of the prison, and when prison policy suggests that a 30-day limit on solitary confinement. Early in custody, Allen maintained innocence and believed solitary was meant to tear him down. He told the psychologist, Dr. Monica Walla, he felt like a broken man after 2 weeks. The brief describes Allen's behavior suddenly worsened in late March and early April 2023, with his weight dropping from 180 to 135. They wrote that he ripped legal mail, washed his face in the toilet, and drank toilet water. The brief describes him as refusing meals, hitting his head against his cell wall, acting like he was from medieval times, stuck a fork into his genitalia, and covered himself in feces, spit, and vomit. Some people say that it was an act. A prison psychiatrist, after seeing him naked, covered in feces with brown fluid from his mouth from eating it, found Allen very psychotic, hallucinating, incompetent to consent to treatment, ordered involuntary medication, and found him gravely disabled. This is Judge Gull. When Allen's attorneys informed the court of his dire condition, the court also refused to move him, and the prosecutor delayed and mocked counsel's concerns while collecting evidence of Allen's confessions. The jury did not hear Allen the morning he started confessing, telling his family in 3 intertwined calls that he was confused and losing his mind. The first call at 3:12 a.m. on April 3rd, Allen told his dad he was losing his mind and was uncertain how much longer he was going to be lucid. You guys know I would never do something like I've been accused of. Allen felt he had been mentally tortured like he was in Guantanamo Bay and that there were drugs in his coffee and Kool-Aid. In the call the jury heard at 5:14 a.m., Allen told his wife for the first time he thinks he killed Abby and Libby and evidently did it. Allen could not remember what he told his dad on the earlier call. A third call at 8:45 a.m., a panicked Allen told his wife he was not sure if his original call to her was a dream. He said he was not drinking the water or the coffee and questioned whether the attorneys who were coming to visit him were his attorneys. The jury only heard the second call with the confession, along with Indiana State Trooper Brian Harshman's opinion that Allen showed no indication he was under duress or stress when he made that admission. The brief argues that Allen's statements weren't made voluntarily, but he was essentially coerced by the effects of prolonged solitary confinement on his mental state. Allen's attorney also argued that being sent to state prison before his trial was unprecedented and unconstitutional. So the right to present a complete defense. So the sketches. On the first day of jury selection on the trial in October 2024, prosecutors filed a motion to block Allen's defense team from referring to a pair of composite police sketches investigators used for years to generate tips on the 2017 murders. Stacy Diner, part of the prosecution team, argued the day before the testimony started that prosecutors believed the sketches would be part of the opening statements by the defense. Diner said the prosecution didn't plan to bring the sketches, one released 4 months after the murders in 2017 and the second in 2019, into the trial, or to call either of the witnesses who helped forensic artists put them together for the facial features. So, as you can see, these two are completely different from one another, right? So the state concedes that Bridge Guy's identity was crucial to the case. Allen's attorneys argued in appeal that the sketch was critical to Allen's defense of mistaken identity, and the judge's decision to exclude it was arbitrary and disproportionate to any legitimate government interest. An expert witness on bullet markings, Gull sided with the prosecutors ahead of the trial to bar testimony of William Tobin, a forensic metallurgist lined up by the defense to testify about the accuracy and reliability of the state's examination of a bullet found near the girl's body. Remember, it's expert witnesses, battle of experts, right? And they were barred from bringing the expert in. Gull agreed with the prosecution, who had argued that Tobin isn't qualified as an expert in the field of firearms examination. In her ruling, she said that Tobin is not a firearms expert, has not training in firearms identification, and has never conducted a firearms investigation. She wrote that Tobin had not examined the evidence introduced in trial. The brief filed this week contends that the state experts credibly was centered to the case, and the judge arbitrarily excused Tobin. Then there's the phone data expert's testimony. During the trial, Stacey Eldridge, a digital forensic consultant for Richard Allen's team, testified that Libby's phone logged an audio output deep in the phone's software, suggesting that headphones or a car aux cable was put into Libby's phone jack about 5:44 p.m. February 13th. She testified that the data showed that somebody removed the headphone jack at 10:33 p.m. that same night. That testimony challenged the prosecution's timeline of the murder by hours. That day at trial, Sergeant Chris Cecil, an Indiana State Police phone expert, testified that during a break in the trial, he Googled possible reasons for the headphone jack issue, and he testified that he'd found reasons on Apple troubleshooting sites, including moisture and dirt. Hang on, let me go Google that, and I'll come back and testify about it. Is that reliable? So as you see, they have got a lot of different claims that why he should get a new trial. So the it is now the prosecution's or the state's appeal, right? So we already know the statements of the facts. We know that the girls were unalived with a box cutter. Trying to get to the arguments. Talked about the confession. Okay. Alan's Frank's claim is waived in several respects. It is a meritless. Liggett did not include false statements or omit material information from the probable cause affidavit, and the affidavit still establishes probable cause, even if the challenge statements and omissions are excluded. Alan's challenge to his confessions is waived. The trial court properly excluded inadmissible evidence. Blair's investigatory sketch of Bridge Guy was not relevant because she did not identify Alan. It was unduly prejudicial and it was admissible hearsay. Tobin's testimony was not relevant because it went to the admissibility of a firearms identification evidence as science, not to witness credibility, and a firearm identification evidence is admissible in Indiana. The audio of Alan's movements videos was hearsay. His 2 jail calls on April 3rd did not fall under the doctrine of completeness. Dr. Grasson's opinion that Alan's confessions were false were impermissible vouching evidence. Third-party motive testimony opining this was a ritual killing was properly excluded under Evidence Rule 403. It is impermissible, speculative, unsupported by any odinists who could be connected to the crimes, and based on inaccurate or highly disputed contentions about the crime scene. Alan's proffered third-party suspects were unduly speculative and did not tend to show Alan had committed the murders. Holder had a confirmed alibi, make it impossible for him to have committed the crimes. And Alan never contended that Westfall, whose sole alleged connection to the crimes was his Odinism, could have committed the crimes by himself. An error, so they said that the way that Abby and Libby were found and that they had some branches on them and the way that the blood was let out of one of them said that there had to be more than one culprit, and that the way that they were placed, etc., is connected to sort of a ritualistic sort of Odinism symbol. An error in the exclusion of any of this evidence was harmless beyond a reasonable doubt based on the eyewitness testimony of Alan's statements placing himself at the scene. The presence of a .40 caliber cartridge cycled through his gun at the scene and his numerous confessions. The admission of the Google search for an alternative theory explaining that the cell phone's audio output code was harmless error. None of the theories for that code made it more or less likely that Alan killed the victims. The trial court properly denied Alan's motion to correct error. Alan did not show that the state offered demonstratively false testimony because he did not verify the date and timestamp of the surveillance video, nor did he establish a foundation for the FBI pinging evidence. Allen had an adequate opportunity to impeach the witness with the evidence, but he strategically chose not to. Last, this evidence would not have impeached Allen's confession to seeing the van. So, what does that mean? So, in Allen's confession, excuse me, there was a house not too far down from the bridge. So the girls walk down the bridge and they're at the end of the bridge. And just at the end of the bridge, there is an embankment that goes down, and there's like a house somewhere over there. And there's a road that goes through. And the house, there was a person who was driving their van, and the van was coming through on the road, and they were at the end of the bridge. And it's alleged in his confession that Allen saw the van and was spooked by that. And so he took the girls down the embankment. So instead of going straight, they went sideways down the embankment, down through some water, and then over to like another side. And that's where they were unalived. So he stated that he saw a van, and the van sort of matched the time frame of this gentleman who was coming through, and which kind of lines up to the timeline. Okay, so argument one. The court properly admitted evidence found pursuant to a valid search warrant of Allen's house. The search warrant of Allen's house established probable cause. Therefore, the court properly admitted evidence found in the search. The gun, the .40 caliber cartridge, was found in the bedroom. The blue Carhartt jacket and knives. Weren't the knives that were used in the event because they didn't have any blood or DNA on them, but they found knives. The vast majority of Allen's first Frank's motion memo and all of the subsequent Frank's motions are addressed to arguments about the warrant's affidavit's validity that Allen has abandoned on appeal. Allen did not preserve this issue for appeal. His Fourth Amendment challenge to the admission of this evidence suffers from multiple issue preservation problems. First, Allen waived this issue entirely by failing to object to the evidence at trial. A pretrial motion to suppress is insufficient to preserve an issue for appeal. To preserve a claim or error, the defendant must contemporaneously object to the admission of the challenge of evidence at trial. Allen did not object when the state elicited testimony pertaining to the search of his house and firmly stated that he had no objection to the admission of the gun and the cartridge, and that the photographs of the Carhartt jacket and knives. By failing to reassert his Fourth Amendment challenge at trial, and instead stating that he had no objection to the evidence was proffered, Allen has waived appellate review of his challenge to the warrant. Take it as it may, right? So let's just scroll. Let's see. The only statements and omissions Allen claims showed more than reckless disregard of the truth are the two statements pertaining to the blue jacket. One of those statements, Allen's description of the clothes he was wearing, is not properly before this court at all and will be argued below. That leaves only Carbaugh's description of the coat available for fundamental error review. Excising that sole statement from the affidavit does not undermine the existence of probable cause and thus the validity of the warrant, much less undermine the fundamental fairness of Allen's trial. Okay. Allen has not shown that probable cause for the search warrant was predicated on false statements or material omissions. Waiver notwithstanding, Allen has not established a Frank's violation, and probable cause exists to issue a warrant when the totality of the circumstances set forth in the affidavit demonstrates a fair probability that evidence of a crime will be found in the location. So Illinois versus Gates. Search warrants are presumptively valid and in assessing whether an affidavit established probable cause. Doubtful cases should be resolved in favor of upholding the warrant. So, this is their argument on that. The affidavit did not contain false statements. Liggett's representation that Sarah Carbaugh reported seeing a muddy and bloody man who was wearing a blue colored jacket and blue jeans was not a false statement, much less one made knowingly, intentionally, or with reckless disregard for its truth. Allen's claim of falsity rests on the video of Carbaugh's June 7th, 2017 interview, where she is the only one heard describing the man as muddy and not bloody. And she said he wore a tan or light colored coat with a dark hoodie or sweater underneath. But Carbaugh was interviewed 3 times, all before the warrant affidavit was prepared, and Allen ignores Carbaugh's description of the man in her second and third interviews, which show that neither representation was false. Those interviewed, Carbaugh described the man as bloody as well as muddy. Allen acknowledged at the trial that she described the man as bloody 16 times in her third interview and said he looked like he had slaughtered a pig. She even marked down where she saw the bloody spatter on the picture of Blood Guy during an interview. Bridge Guy, not Blood Guy. So that's interesting. Material information defeating probable cause was not omitted in the affidavit. Allen also claims the affidavit omitted material information by failing to include detail of Blair's description of the car she saw parked at the old CPS building that were inconsistent with Allen's Ford Focus, and details of Blair's description of the man she saw on the bridge that was inconsistent with Allen's appearance. Allen did not show these admissions were designed to mislead or made with reckless disregard about whether they would mislead, nor did he show that the inclusion of this information would have defeated the probable cause. Specifically, that the man appeared youthful in his 20s or 30s and had poofy hair, and that the car was shaped like a 1965 Comet and was nondescript, dark color, but was not black, white, or red. All right, let's go down. Right, so there were 2 entrances to the Monon High Bridge. One is the Freedom Bridge entrance, and the other one is by where the girls were dropped off by the farm, the Mears entrance. So supposedly, Allen had parked by the Freedom Bridge entrance, and the girls were dropped off at the Mears. The Freedom Bridge entrance is really far away, and he would have to snake through. And there were several people who were actually there, that some girls and what have you, who had seen Richard Allen that day. But when Richard Allen left, he did not leave correctly. He went a different way. All right, let's scroll. Okay. The court properly admitted Allen's confessions. Although Allen did not preserve this issue, the trial court properly admitted confessions Allen made to his family, Dr. Walla, and correctional staff. The confessions were voluntary, not the product of state coercion, and therefore did not violate his due process rights against self-incrimination under the 5th and 14th Amendments. To the extent Allen requests an alternative remand to hold a Franks hearing, he does not cite to authority for the proposition that such a hearing can be held post-trial while an appeal pends. He also has not identified any evidence he could present at a hearing beyond the 133 exhibits he already submitted to the trial court in support of his motion. He had a full and fair opportunity to create an evidentiary record to support his claim, and this court has sufficient information to conclude that Allen cannot meet his burden of proof. Both the federal and state constitutions prohibit the admission of involuntary confessions. A confession is involuntary when a person's free will has been overborne by violence, threats, promises, or other improper influences. Coercive state action is a necessary predicate to finding involuntariness under the federal Constitution. The Constitution is not concerned with moral and psychological pressures to confess emanating from sources other than official coercion. Mm. This remains true even when a defendant suffers from mental illness. A defendant's mental state is not enough to render a confession involuntary in the absence of coercion police activity. Evidence of a defendant's mental condition that impaired his cognitive and volitional capacity is never by itself sufficient to render a confession involuntary for purposes of due process. All right. Allen's confessions were not caused by the allegedly coercive conduct. For a confession to be involuntary, the coercive state of action must casually relate to confessions. Okay. On May 3rd, Dr. Walla added a diagnosis of brief psychotic disorder with marked stressor to his record for his presentation within the last month. This diagnosis applies when a person exhibited one or more symptoms of psychosis, not better explained by another diagnosis that lasted more than one day, but less than 1 month in reaction to an event that would be markedly stressful to anyone in the circumstances. So, see, they also had problems with Dr. Walla, and that Dr. Walla had read or heard about the events happening in this case, and that they felt that she fed him the information about the person driving the van. And I'm surprised that that's not in here, but maybe they're waiting for. So, if you appeal and it gets denied, you had then get to appeal again. So, maybe they're holding it back for the next appeal if this one gets denied. Other constitutional challenges are meritless. The admission of Allen's confessions did not violate the due course of law. Stating where they erroneously cited something which doesn't go through this. Okay, the trial court made proper evidentiary rulings. The trial court's evidentiary rulings were correct and did not deprive Allen of his rights to present a defense. Trial judges are better at making evidentiary calls than an appellate judges. Therefore, trial courts are given wide deference in this area. In many cases, a court could admit or exclude evidence. An appellate court won't meddle with that decision on appeal. Manifest abuse of discretion. So typically, appeal courts do not want to overturn trial courts. Allen has waived this issue. The trial court granted the state's motion in limine to exclude the police sketch drawn from Blair's description of the man she saw on the bridge. Rulings on motions in limine do not preserve errors for appeal. That could be an issue. In additional arguments, Blair's sketch could impeach Carbaugh's identification or show bias in the investigation. Allen did not make an offer of foundation from Blair's sketch artists for admission on the sketch. Allen's argument on appeal that the sketch was admissible because it was not a statement under the hearsay rule and that it was an adoptive admission by the Indiana State Police are waived because he did not raise these arguments for admission below. Allen's reliance on Roe v. State is misplaced. There, the sketch was admitted to impeach the identifying witness's identification of a defendant. Here, Blair did not identify Allen, so there was no identification of the defendant to impeach. Tobin's testimony was inadmissible because it was not relevant to any issue before the jury. Tool mark identification has at least two subdisciplines: metallurgy and firearms identification. ISP forensic firearms examiner Melissa Oberg testified that she used the Association of Firearm and Toolmark Examiners toolmark identification methodology and opined that there were three different toolmark areas of significant agreement to show that the cartridge at the scene had been cycled through Allen's Sig Sauer model P226 40 caliber handgun. Defense expert Eric Warren, also a forensic firearm examiner who used the AFTE methodology, testified that he reviewed Oberg's report, did not agree with her process of comparing a cycled cartridge with a firearm cartridge, and found insufficient documentation to support her opinion. There was a battle of the experts. Allen also proffered William Tobin as expert in metallurgy. Tobin is an open critic of the AFTE and all firearms identification methodology. He believes the discipline is unreliable and should not be admitted in court. The trial court properly excluded this testimony because it was not relevant to an issue before the jury. Tobin's proffered testimony went to the reliability and the admissibility of the firearms identification evidence. Interesting. Because the trial court found the firearms identification evidence admissible, it was for the jury to determine the credibility of Oberg and Warren and assigned weight to the evidence. Tobin's proffered testimony was not relevant to credibility. Tobin is not trained in the forensic firearms identification, does not do firearms examinations, and did not examine the evidence. Well, that's interesting. Allen presented 15 videos of the movement of the DOC during April through June 2023 to show how the environmental conditions affected his mental health, which impacted the credibility of his confessions. The trial court sustained the state's hearsay objection to the audio of Allen's statements, so the jury saw Allen but did not hear what he said during the movement periods outside of his cell. Only the audio was relevant to present his environmental conditions. Allen's sole argument on appeal is that statements were not hearsay under Evidence Rule 801 because the statements showed his state of mind. But Allen's statements do not facially pertain to his state of mind, and Allen's attempt to use them for the purposes shows that he was offering them for the truth. He wanted the jury to accept substance of his statements as true reflections of the contents of his mind. Ooh. Talk about his other phone calls. I want to get to the third party culprit. Okay, evidence of two third party suspects. The trial court properly excluded Allen's proffered alternative suspect evidence pertaining to Brad Holder and Patrick Westfall. Allen was permitted to present evidence challenging the quality of the police investigation and their long-term suspicion that more than one individual had been involved in the crime. But the court excluded his specific third-party suspect evidence because Allen failed to establish any nexus between those individuals and the crimes. To be admissible, evidence must be relevant. It must tend to make a fact of consequences more or less probable than it would otherwise. Evidence which tends to show someone else committed the crime logically. Allen asserted that several other individuals acted in concert with Holder and Westfall to commit the ritual killing. He never claimed below that Holder and Westfall had acted alone. Upon appeal, he has abandoned any claim that evidence pertaining to those other individuals should be admitted. Okay, makes it less probable that the defendant committed the crime and thus meets the definition of Rule 401. Okay, Holder had a confirmed alibi that made it impossible for him to have kidnapped and murdered the girls shortly after 2 p.m. on February 13th, 2017. But Perry Mason made it look so easy. The admissibility of evidence offered by a criminal defendant to suggest that someone else is guilty. That's cute. Holder worked at a landfill in Buffalo, Indiana. His work records confirm that he worked February 13th from 4:45 to 2:45 p.m. At his gym record, he showed him checking there at 4:08 on February 13th. The operations clerk for the landfill, the only person who could make changes to the electronic time records, confirmed that she had not changed them. Okay, so what about the other guy? Without Holder, the theorized connected to Westfall necessarily fails. It was a central tenet to Allen's ritual killing theory that the crimes were not committed by one person. He never contended below that Westfall committed the crimes by himself. Westfall's alibi, that he was with his son that afternoon, was corroborated by his son. Holder's ex-wife's statement that Holder said Westfall murdered AW or was involved in the murders, statements Holder denied making, were inadmissible hearsay. Apart from that, Allen points nothing other than the fact that Westfall was an Odinist. At best, this is weak, speculative motive evidence predicated on speculative and inaccurate reading of the crime scene. Harmless error. Any of these alleged errors, individually, collectively, are harmless given the power independent evidence of guilt. The timeline and eyewitness evidence, including Allen's initial statements to police, creates an overwhelming certainty that Allen was Bridge Guy and thus the murderer. All right. I don't know how many pages this is. Maybe it says at the top. The trial court properly denied Allen's motion to correct error because the state did not knowingly present false testimony through Weber in violation of Napier versus Illinois. A conviction obtained through the use of evidence that the state knows is false and does not attempt to correct violates a defendant's 14th Amendment due to process rights. Allen failed to show that the state presented false testimony through Weber. Okay. In conclusion, the court should affirm the trial court's judgment. XOXO. The appellate people. Let me see. I don't know when this was filed. Oh, on March 25th of 2026. So the state just went ahead and filed that. Let me see if I can quickly. Okay. Let me see if I can find an image. Oh yeah, here's a good image. Okay, let's bring this up. Where am I? All right, we're going to stop sharing that and let's see if I can bring this up. See if I can bring this out. Let's do that. Dum-dum. Dum-dum. Okay. Back to the stage. All right, so I'm going to just make this bigger. Okay, so here is the CPS building. This is where supposedly he had parked his car. And, oh, boy, you can't. So this is the city of Delphi. This is the bridge. And then there's like a road leading here. I wish it was zoomed in a little bit bigger, but I can't. It's all right. So you park over here and you come down. There's like a path. You see this path? So you come down here. There's like a bridge here. You walk here, there's the bridge. This is the Freedom Bridge. And then you walk down here and you come down over here and you snag around here. And then this is the bridge. And so this is the Mears parking lot. This is where the girls were dropped off. And there's like a little path to come here and go down here. So they went down to the bridge and there's like there's a road right here. And there's a house somewhere over here where a van was driving. Girls went down to the edge of the bridge. They went down, went through some water, and went like somewhere over here is where they were unalived. And then they say allegedly Richard Allen went up through here, went over here, passed over here to get back to his car. And that's where they say things happened. So with that, we're going to go ahead and end our recording for the Richard Allen appeal. This was just filed, the state filed it on March 25th. So it's going to take a long time for them to either hear it, deny it, or whatever. So we still have other appeals happening. We have Alec Murdaugh's appeal. We also have Charlie Adelson's appeal, and we're still waiting on that. So we're in sort of the appeals category right now. We have 3 appeals we're waiting to hear from. So with that said, let me know what you think. Do you think Richard Allen is guilty and that he is the person who unalived Abby and Libby and therefore appeals Schmiel that, yeah, so he was held in prison and he was held in solitary confinement and he went cuckoo bananas and therefore he made these false confessions, or he made these confessions knowing these things, he had lucid dreams and he ended up saying things and confessed? Or do you think it was the product of his conditions of the jail? Also, should he have been jailed by himself for that long of a period? Is that, cruel and unusual punishment? So should the jailhouse calls be allowed in? Should they have been allowed to have a third party culprit? Someone else did it, right? But again, you have to kind of connect somebody, right? They did that sort of in Karen Reed's case. Somebody else did it, right? And then the police were terrible. So that happened in a second trial. The police were terrible, and that is how they went through that case. Is it the product of Odinism? And should they have been able to get the search warrant and search his house? And should the other expert for the cycling of the casing have been able to testify? So those are the things that the appellate court has to look at to state whether or not that the defense was right and therefore the trial court erred and he needs a new trial. Or do you think that the state says, nope, trial court did not err and therefore his conviction stands? So let me know what you think in the comments. Thanks for watching. Follow me and if you want to hear more about these cases we're following and much more. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.